Welcome to another edition of the Western Michigan University Cooley Law School's Community Conversation series. I'm Paul Zielinski, your facilitator for tonight, and our discussion today is going to focus on the recent election results and the multitude of challenges and defenses of those results. We have just the right person to help navigate us through this conversation, constitutional law professor and scholar Devin Schindler. His impressive bio is in the posted chat that you see to the right of your screen. And in addition to being named a super lawyer by the Detroit News, Professor Schindler has also been named as one of the best lawyers in America. Professor Schindler is a frequent commentator on numerous constitutional issues, being interviewed over 200 times by radio, television, print, and internet sources. His comments have appeared in Time Magazine, the Huffington Post, the New York Times, the San Francisco Chronicle, and numerous local media outlets. Now, I want to remind everybody, this is a conversation, so we hope that you'll engage with us as well. You can do that one of two ways. You can put your question in the chat, or you can unmute yourself and ask the question directly of Professor Schindler. But if you're not speaking, we ask that you go ahead and mute your audio. So let's get this going. On November 2nd, Professor Schindler, you joined SiriusXM's Patriot channel to discuss why it isn't unprecedented to know election results on Election Day. Now, before you make the opening comments, I have a question for you. In your interview on the Patriot channel, the notion that we call, and I quote, "the notion that we call the election on Election Day is something that has been made up by the media. If you want to be specific about it, elections are called on January 6, 2021, this time around, when Congress meets in a joint session to count the votes." So, with everything that's going on, to get us going, Professor Schindler, in your opinion, what will be the outcome on January 6th?
To answer your question, Mr. Zielinski, Paul, given the record, there have been approximately, by my count, 290 lawsuits filed prior to the election and after the election cycle. During that period, the Trump team has won two of them on very small issues. Looking over the legal claims, I've had an opportunity to read probably 100 of the briefs. I've read all of the opinions. It does not appear that there is any claim that is going to result in 4 states' votes being overturned. So I'm highly confident on January 6th, as the Constitution requires, the first Monday after the second Wednesday when Congress sits down to count the votes, that they will in fact certify as a constitutional matter the election of President-elect Biden. But in the words of the great poet philosophers from San Francisco, the Grateful Dead, what a long, strange trip it's been. We're not done yet, but let's put it this way. President Trump is the Detroit Lions. He's down by 30 with 2 seconds left in the fourth quarter, and the other team has the ball. So if you'll accept my analogy, I am highly confident that the constitutional structure will be respected, the vote of the people will be respected, and President-elect Biden will be selected on that fateful day.
So yesterday we learned that there, at this point, 17 attorneys general filing a petition with the Supreme Court to overturn the results. What do you make of the group of 17? And how's this going to play itself out, do you think?
So the argument is that we are treating absentee ballots, mostly Biden votes, differently than we are treating unequally to the way we are treating in-person votes. So the first equal protection claim is based on the distinction between absentee voters and in-person voters. The second equal protection I've seen is that districts would treat voters differently. In Philadelphia, they had allegedly addressed the cure proposal or a cure system in place. Oh, your signature's not perfect, we'll call you in, you get to cure your ballot. The more right-wing rural areas were not doing that. They were just rejecting absentee ballots much easier, much more commonly than the absentee ballots were being rejected in, say, Philadelphia. Again, unequal treatment depending on where you voted, or at least that's the claim. The big claim, about that in a bit, the big claim here is the Electors Clause. And this actually has some traction. I don't think they've got the standing to really bring this case. I think it's too late for reasons I'll explain in a minute. But this really does present an interesting question. Article 2, Section 1, Clause 2 and 3 of our grand Constitution, the powers of the president, states, each state shall appoint in the manner as the legislature thereof may direct the electors. The key word there is in the manner as the legislature decides. The claim here is that a number of these new voting absentee rules brought about because of the COVID-19 crisis were not implemented by the legislature, but rather by Secretary of States. For example, in the state of Michigan, the Secretary of State, using delegated authority from the legislature, allowed individuals to request absentee ballots online. Now, we joined the 21st century. Now, there's no specific statutory authority allowing that. Wisconsin, the Secretary of State allowed for a number of drop boxes. Again, no specific authority from the legislature to do that. And then perhaps most famously at this point, the Pennsylvania Supreme Court, not the legislature thereof, Pennsylvania Supreme Court ruled that late arriving ballots from 3 days after the election could be counted. The argument here is all of these new absentee ballot rules were not implemented in the manner the legislature directed, but in the manner that either the courts of the state or the Secretary of State using delegated authority directed. The argument is they're not the legislature. About all the votes. This is an interesting situation because the Supreme Court did rule a few years ago in an Arizona case where the people did a ballot initiative to change how areas were redistricting, said that the legislature means the law-making body of the state. So when they said legislature, does that mean the law-making body can be the Secretary of State operating under delegated authority, and the law-making the Supreme Court of, say, Pennsylvania? So this is the claim that may have some traction someday, but I don't. There's glimmers, sort of mentions of procedural due process. You took my vote without giving me a process, and what we call substantive due process. You've deprived me of my fundamental right to vote. So at the core, Paul, there's a number of state claims here that I'm not going to get into, but those are the three issues that really have arisen from a constitutional perspective that the Supreme Court is now being asked to decide. And Paul, I got on my soapbox, and I forgot the question. So please remind me.
So I can bring you back, no problem. So going back to your comment about, so you have the legislative body, you have secretaries of state, and so now we have attorneys general kind of getting into the fray here to try to change the outcome of the election. What's their basis from which to stand to even ask the Supreme Court to act?
Well, two ways to answer that question. First, under our system, the Supreme Court gets its authority or jurisdiction from two different places. Most cases come up on appeal. You file in district court or you file in state court. You work your way up to the Court of Appeals where I used to work. And then if you lose there, you can ask the Supreme Court to hear the case on a writ of certiorari, excuse me. But the founders gave two categories of cases that they wanted filed directly in the United States Supreme Court, deciding that there were certain disputes that had to go to the highest court right out of the box. The first, not relevant, has to do if you sue an ambassador. The second, however, is the founders said if a state sues another state, that's going to be an important issue, and we want that case to start at the Supreme Court level. So constitutionally, that's why they are starting at the Supreme Court level, because the Constitution suggests that when a state sues another state, that's where we go. The complaint, and it's called the Bill of Complaint, where they actually request permission to file their complaint, basically makes those three claims, Paul. The equal protection claim that the state of Michigan and the other four states that they're suing deprive voters of equal protection, deprive voters, violated, the Electors Clause, and then finally violated due process. So it's a variation on the theme we've seen before. You know, all these claims have been made before in lower courts and rejected for reasons I could get into. But now, for the first time, second time actually, these claims are directly in front of the Supreme Court. I should note a similar claim was made under the Electors Clause in Pennsylvania, made its way up to the Supreme Court. The Supreme Court rejected that claim without dissent in a one-line opinion. So the Electors Clause has come up, but through that other process, through the writ of certiorari.
So are you anticipating a similar result that the Pennsylvania case got with the 17 states, 17 attorneys general?
Put yourself in the position of Chief Justice Roberts, or the three newly appointed or relatively newly appointed justices, Justice Barrett, Justice Comey, Justice Gorsuch. You haven't been around very long. If you're the three of them, you're going to be concerned about stepping into this particular mess, because if the court does decide to take these cases, no matter how they rule, they are going to potentially undermine the respect we have for the court. So my three non-originalists, most people call these my liberal judges, Kagan, etc., certainly are not going to want to touch this case. Justice Roberts is not going to want to touch this case because he's an institutionalist. He believes that we should, the court needs to protect its own sanctity. He's not going to want to touch this case. It takes 5 votes, not 4, for the court to accept this bill of complaint. I think I've got 5, 6, 7 votes to say we should not step into this, because those who don't learn from history are doomed to repeat it. Look what happened to the respect the court got after Bush v. Gore. It damaged the respect we have for the court. A lot of people were very upset and envisioned or pictured the Supreme Court not as a legal body, but as a political body. So I'd be very surprised, for both practical and legal reasons. Legal reasons, because these claims have been vetted and rejected. Practical reasons, the court needs to protect its foundation. So for both those reasons, I'd be very surprised if the court case at all.
Gotcha. Our colleague and friend, Professor Kim O'Leary, is asking a question. Kim, do you want to turn on your camera and your phone and ask it directly of Professor Schindler?
Sure.
Thank you.
Hold on. There we go. Yeah. Hi, Devin. My question is, how can it ever be fair to challenge the process of voting after the voting takes place, when there was plenty of time to challenge the process of voting before the voting took place? And wouldn't latches apply?
Professor O'Leary, as is so often the case, you would drill right to the core of it. In preparing for today's speech, I looked at a little Shakespeare. How do I lose thee? Let me count the ways. If you read through all of these decisions in the lower courts, I've counted 15 different ways the Trump team has lost. One of those ways that the Trump team has lost, and pretty consistent, is the concept of latches. If you wait too long to bring your lawsuit, and your wait somehow prejudices the other side, the court simply won't hear it. And in fact, one of my courts in Pennsylvania, an opinion written by a Trump appointee, district court judge, cited that exact fact. You knew these rules were in place months ago. You didn't file your suit. Or you knew the election results on November 3rd. Why did you wait 3 weeks when we're on the cusp of the December 8th safe harbor? Why did you wait? So you're absolutely right, Professor O'Leary. Any number of these 50 cases, and the 240 before it, for that matter, have been just one of the grounds for the dismissal is, you knew the rules. Why did you wait? Well, I'll tell you why you waited. Because you wanted to see the outcome of election. You wanted your cake and eat it too. So yes, absolutely. I've got this whole list. They've lost for any number of reasons, but that's a critical one.
And so, just as a quick follow-up, I just have to say, I'm a lawyer, but I'm a voter. And what just keeps, I think because Michigan is one of the states that's being challenged, if you're going to tell me I couldn't vote lawfully following every rule that I followed to be able to vote, I would have found another way to vote. It's just not right. You can't steal my vote. So, that's just a very emotional response. That's not a lawyer response, but I've been feeling it.
But Professor O'Leary, there is, as you are such a brilliant woman, there is a strand of law in that. And the strand of law is equitable remedies. Several of these courts have rejected these claims really based on what you just said, that it is beyond the power of the court to disenfranchise millions of people who followed the rules that were in place at the time. Even those rules might not have been perfect. There is an equitable reason for us to stay out of it, a reliance interest. The voters relied on the rules. The rules might have been perfect, but the remedy is certainly not to disenfranchise millions of voters.
Professor Schindler, John Campbell beat me to the punch. This is my next question kind of in this area. So behind all of these filings and these cases that go forward, there are attorneys who are acting on behalf of President Trump. What's your sense of, kind of post all this in terms of sanctioning attorneys, the Rudy Giuliani's of the world? What do we think is going to be, should the profession respond to these attorneys who are filing these claims?
It was interesting because Sidney Powell came out, right, and released the Kraken. Well, filed 4 lawsuits, and the 4th got dismissed 2 days ago. So the Kraken turned out to be a dead goldfish. You read some of these briefs, you read some of these complaints, and you just have to go, if my law students wrote this, I would fail them. Because there have been no, I'll be fair. A lot of these cases were written up very quickly. I understand that may not have a lot of time to do it right. But in all 50 of these cases, or the 48 that have essentially been dismissed, in many of them, the courts have pointed out bad lawyering in a way that courts don't normally do it. For example, several of these lawsuits cited as one of their key pieces of evidence an affidavit from a fellow by the name of Russell Ramsland, a security consultant. I think I want to do that in my next life, be a security consultant. He had wrote up an affidavit saying that in Michigan and Wisconsin, we have overvotes in numerous precincts, 150% overvotes, 200%. And he cited like 14 Michigan townships where there are overvotes. Oops, those townships were in Minnesota. So the Minnesota and the Michigan townships had the same names. So he said, well, this township has 10,000 people, but there was 12,000 votes. No, the 10,000 people were in Minnesota. The Michigan township had 50,000 people. Must be, didn't know Michigan from Minnesota. And this affidavit was used in several of these cases, even after some of these mistakes were pointed out. Making up quotes. The suit that was dismissed 2 days ago, the court, in its opinion, it's an amazing paragraph. Ms. Powell states that the court below said, or another court, precedent says blah, blah, blah. The court has read this other case 3 times and can't find this quote. Apparently, it was made up. Wow. That's a heck of an accusation. The list goes on. Relying on convicted criminals like Miss Carone, now famous from Saturday Night Live sketches. A convicted felon. I believe it was a felony. We're relying on her affidavit. Look, the list goes on and on of essentially they set a wide net and got a bunch of folks coming back to them making claims that they simply can't support. My lawyers out there and my students know out there that we have a legal obligation to zealously represent our clients. God bless lawyers that zealously represent their clients. But we are also officers of the law and ministers of justice, which means our complaints must be well-founded. Our claims must be well-founded. And I'm seeing in a lot of these cases claims that are being made that are simply not well-founded. So, I don't want to step over my bounds here, but I think Sidney Powell should be concerned in particular because a lot of the claims she made simply lacked legal or evidentiary support, and it's been called out at this point.
So what would be the process for Sidney Powell, for example, who kind of was way out of bounds? Some have thought about the initial comments that were made at that press conference. I don't know how many weeks ago it was now. what might happen to her? I mean, this is for obviously all the law students and potential law students in the room, that if you make a claim or a statement, that it could have consequences.
It's funny because we have the First Amendment now, one of my other loves, and the famous In re Jeffrey Feiger case out of the Michigan Supreme Court. There's a difference between what lawyers say in press conferences and what they say in court. In court, we have processes. It's called Rule 11. Somebody lies, somebody files a complaint that's not well-founded, you can seek your attorney's fees from them. We also have, if you really step over the boundaries, we've got our own internal, of course, our system, the state bar here, has its own internal grievance commission that hears claims that, generally speaking, lawyers have stolen money, things of that nature. But I saw that there's been a petition out there to essentially disbar Sidney Powell for what she's done. And I wouldn't be surprised if that process wasn't followed. Problem is, or the challenge is, lawyers have First Amendment rights too. So they have much more leeway outside of the court than they do in the court. Basically, a lie outside of the court, unless it really undermines the administration of justice, you can't touch the lawyers. For example, Rudy Giuliani, fraud, 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 fraud in his press conferences. He goes into Pennsylvania, argues it's the first case he's argued in 30 years. He's asked by the court, is this a fraud case? And he went, oh, no, this is not a fraud case. It's a constitutional case. It's not a fraud case. Well, he had to pivot. He had to pivot for a couple of reasons. Among those, you don't want to engage in a fraud on the court.
So sticking with the fraud idea, there are a lot of people that are buying in that the elections have been rigged or it's all a fraud. And Graham Ward, our friend Graham Ward, talks about behavioralists have shown people who hear something which is false, if they hear it enough, forget it was false. If the court simply says we won't take it, or that states no standing, then the divided public is free to continue believing what they like rather than what is true. What's your take on that?
The behavioralists say, and great question, Professor Ward, the behavioralists that I've seen, I've actually written a bit on this, say you have to hear something 7 times from 7 sources before you believe it. And of course, we have the countervailing message out there too. Look, the Constitution does not guarantee a perfect election. It guarantees a fair election. There's no doubt that there's going to be a percentage of America that will never, ever, ever believe we have a fair election. But I think about groups like the Tea Party that were all the rage, and then time passed and it wasn't the rage. This too shall pass. You don't hear many people arguing anymore that Gore, his election was stolen from him. Time passes, time heals. So yes, I'm always going to have a group, and I've put it at about 20% of America, that's never going to believe this election's fair. But I believe as time goes on and we see that the Constitution still works, that we still have the ability to vote, we still have the ability to choose our leaders, that our leaders are responsive at some level. I think this is a wound that can be healed. Not for everybody, but I think at the end of the day, the vast majority of Americans, even those that think the election was somehow fraudulent, are going to come around and see. That's why I think it's critical for the Supreme Court to stay out of this, because we don't want the court to even give credence to some of these claims, which have been disproven time and time and time again. You're not going to you're never going to convince everybody, but I believe we can convince enough Americans that the system works, that the American polity, in my mind, may come out of this even stronger than before the election. I
hope you're right. So let's talk about the question of standing. And Corey's asking, does Texas even have standing? It'd be hard for Texas to prove injury from a Michigan election. So the interstate issue that you were talking about earlier.
I'm so excited, Paul. I keep cutting you off. Yes. In my list of 20 reasons why the Trump supporters have lost, not mine, these are by the courts. Number 1, with a bullet, is the standing problem. Standing requires 3 things. Our Constitution requires you, in order to invoke federal court power, You must show injury, that the injury was caused by the defendant, and that the court can give redress. The court can solve your problem. Here, the lower courts, and Michigan just about an hour and a half ago, I had a chance to look over their brief, argues, look, how is Texas injured here? Well, Texas says, well, our votes have been diluted. That's my Texas accent, by the way. My votes have been diluted. My voters have less value because voters in Pennsylvania can vote by absentee ballot. And it's almost a non sequitur. How have your voters been harmed by the idea that Pennsylvania and Michigan do it slightly differently? Because remember, the Constitution says states can choose their electors differently, the legislature thereof. So the fact that Pennsylvania did it differently than you, Texas, where is your injury? But the courts have also ruled that they lose on redressability. Okay, Texas, let's say somehow your voters were diluted. Their vote wasn't as powerful as it should have been. Still a stretch. What's the redress? You want us to disenfranchise the millions of voters in Pennsylvania, Michigan, Wisconsin? How does that solve your problem? How does that give you redress? And so the courts have consistently said that these plaintiffs in these cases lose on standing for two reasons. What's your injury? I don't know. My vote, it wasn't worth as much. And what redress can give you? Solve my problem by destroying his vote. Again, a non sequitur. So I think that's the primary reason courts have relied upon to dismiss all of these cases.
Does injury and redress get adjusted, if you will, because there are 17 states claiming that these elections were illegitimate?
Two things. The Constitution requirement, injury is the same for everybody. Now, I will grant you there's a case called Massachusetts versus EPA, for those of you who are total con law geeks, where Justice Stevens several years ago said, well, when a state is suing, we should be very loose with the standing requirements. We should give the benefit of the doubt to the state. Since then, though, my court has turned more originalist and much more stiff on the standing requirements. So if the court is consistent, don't always get consistency in this world, but if the court is consistent with its originalist perspective that the standing requirement is an absolute bar, then the rule will be the same, even though it's a state. I should also point out that standing has a prudential element. The idea that if your problem is shared with everybody, I don't like how the government is spending my money. I'm a taxpayer. I want to sue. Court will say, yeah, you're hurt like every other taxpayer. When we're all injured about the same, the court says that should be resolved through the legislative process, not through the court. It's called a generalized grievance. The courts have also dismissed these cases not only because the constitutional requirements weren't met, but also for prudential reasons. It's a generalized grievance. All Texas voters were harmed in some fashion. Take it to Congress. Don't take it to me. So the voters, the people that have sued, the plaintiffs, the voters, have lost on two standing bases, constitutional and prudential. So they have two hurdles to overcome.
You have us cooking now, Professor Schindler. The questions are just flying in. So what I'm going to do is I'm going to try to take these, if we haven't already kind of addressed some of them.
Poole asked, why do you think SCOTUS had the 4 states respond? After the suit was filed, SCOTUS gave the 4 states basically 2 days to respond to the bill of complaint. The answer is standard operating procedure. Courts do not like to sua sponte, just dismiss complaints. They always give the other side a chance to speak. So I would not read anything at all into that. That is just standard operating procedure.
So, do we have a coup going on here?
The soft coup question. You know, I end my Con Law 1 classes, week 14, asking the question of what happens if a president decides that he and not the Supreme Court is the final arbiter of the Constitution, that he gets to decide what the Constitution says. And so the envisionment here, I suppose, the scenario is President Trump says, I interpret the Electors Clause as saying Pennsylvania, Michigan, Wisconsin can't do it that way. I won the election, and therefore I'm not leaving. I love President-elect Biden's comment on that, saying we are perfectly capable of evicting a tenant who won't leave his house. The fact of the matter is, I don't think it's a soft coup. I think it's even more cynical than that. Note that President Trump has raised $200 million from his plea to his supporters, helped defend the election. And so long as he can keep this up in the air, he can continue to raise the money. There may be some, and I'm not a psychologist, but some simple denial going on here. Remember that back in the day, Nixon was going to fight to the bitter end until a group of 4 senators, Republicans, came over to the White House and said, Richard, Dick, it's over. You need to resign. And he did the right thing. He resigned. I think we are approaching that moment. When and if the Supreme Court rejects the bill of complaint, the game is truly over. And I would hope that at that point, many of the Republicans who have refused to speak or continue to support this would say, you gave it your best shot. The game is over. And without that support, he's not staying. So I wouldn't call it a soft coup. I would say it's the breath of some folks that just aren't ready to face the reality that we had a fair election.
Yeah, in fact, I shouldn't even mention this because I can't cite the source, but on my news feed this morning, I saw a poll that 60% of Americans are asking Donald Trump not to run again in 2024.
On the other hand, there's a poll out there, and I've seen various numbers that 66% of Republicans think the election was stolen. Now, again, I think over time that'll change, but we do have a great divide here. There's no question about it. But call me naive. Every year, I graduate anywhere from 50, 200, 300 students that have had me and the other outstanding professors I have the opportunity to teach with. And they have been trained in the rule of law. And at the end, I want to get into this a little more because Cooley lawyers had an important role to play in this whole process. Out there have been properly educated on the rule of law and are fighting. Hopefully are going to step across the divide and be willing to shake the hand of the people that disagree with them. If you want to do something about this election, go find your neighbor that had a Biden sign if you're a Trump supporter and say, hey, congratulations, your guy won. Let's be friends. Let's work together, or vice versa. At the neighborhood level. And I'm unleashing onto the world lawyers that will continue to defend this Constitution.
So let me ask Professor.
Let me ask Professor Schindler. Hair on fire.
Yeah, who was their common law professor? That are 2 grads who had played a key role. I was wondering who that was.
So let me go into this story. The hinges of history often turn on names you've never heard before. The differences, sort of like the butterfly effect. 2 of our graduates are involved and are part of the hinges of the history of this election. First is a fellow by the name of Aaron Van Leeuwenhoek. Aaron, a little-known lawyer working for the Republicans, giving advice to the Republicans working for the House, got appointed to the Board of Canvassers, a sleepy little committee that nobody pays any attention to, has one job: certify the votes, make sure they were counted correctly. So it comes up, our election comes up, and the board meets, and it was live. I watched the whole thing. It was fascinating. More people watched the Board of Canvassers meet this round than has ever watched in the history of the United States. I have 2 Democrats on that board that were clearly going to vote to certify. I had 2 Republicans, including Norm Schinkel, who has been a partisan for years. The swing vote was a fellow by the name of Aaron Van Leeuwenhoek. Now, Aaron was a very fine constitutional law student of mine. Really, really enjoyed the Constitution. It seeped in it, very engaged, always asking me questions. and always showing a deep, deep respect for our Constitution and the rule of law. And so the vote came down to him. Going to certify the vote and follow the rule of law, or is he going to be partisan? Tremendous pressure on this young man. And at the end of the day, he gave a little speech. It's a speech that I've given before. It's given. As John Adams once said, says Aaron, we are a government of laws, not men. This board needs to adhere to the principles here today. The board must do its part to uphold the rule of law and comply with our legal duty to certify this election. Here's, again, talking about a Democrat here. You're talking about a dyed-in-the-wool Republican who followed the rule of law, giving the 3 votes to certify this election, which was in many ways the death knell of a lot of these complaints. Hinges of history. Our graduates and our students and really all lawyers can make a real difference. And here's a great example of it.
And what role did Matt Hall play?
Well, I was going to say, Mr. Hall. I know Mr. Hall very well. Mr. Hall had me for 4 classes. I did a directed study with him that ended up being a brief in support of Donald Trump. Mr. Hall and I didn't always agree on politics, but I the fact constitutional junkie. Respected the Constitution, respected the rule of law. We didn't see things always the same way, but he was extraordinarily engaged. And now Matt Hall, now Representative Hall, is the chair of the House Oversight Committee that held the election hearings that were most recently mocked on Saturday Night Live. He is a Cooley student that ended up as a character on a Saturday Night Live sketch. Now, again, he ran the meeting. Many of you saw the clips of Ms. Carone. Many of you saw the clips of Giuliani, and it was a bit of a circus. But at the end of the day, Representative Hall did have the decency to say about Ms. Carone's testimony, I don't think it helped us to get to the bottom of what happened here in the election. So I too will even give him his due for, at the end of the day, saying that testimony was not helpful. Again, the hinges of history turn sometimes on the folks that you've never heard of, but believe in our Constitution and the rule of law.
So let's turn to the topic a little bit about the ability for the president to pardon himself and others. And Dee Boyd has a question. Dee Boyd, Dee, I'm going to unmute you. And if you want to throw your camera on, or I think I can, or Terry, can you unmute? Or you can do it yourself too. There you go.
Yes, I think I'm unmuted. Can you hear me?
Yes, you are. Yes, you are. You're good.
Yeah, I just wondered, there's a lot of talk about the president possibly pardoning himself. I was wondering what your thoughts were on that, and looking at the Constitution, there's some ambiguity there on whether he can do so or not. I was wondering what you thought.
What a great question. This is a question that Justice Gorsuch, who is a textualist, he believes you look at the language of the Constitution no further. He was the one, for example, who read the word sex discrimination in the 1964 Civil Rights Amendments and said, well, that includes transgender, because transgender folks should be discriminated on because of their sex. So he's very much a textualist. So we read the Appointments Clause very closely, and it says the president can grant. Think about that word grant. You don't grant yourself anything. You grant other people things. So you can make a strong textualist argument that that word grant is something you give to somebody else, you don't give to yourself. The other thing underlying really our entire Constitution, and at least our judicial system, is the notion that no person should be a judge in their own case. That has been stated thousands of times in thousands of opinions at the core of due process and other things. So from a philosophical point and sort of a founder's intended point, again, a strong argument can be made that the president does not have that authority. In fact, the Office of Legal Counsel, which essentially gives advice to the president, had sort of literally a one-sentence discussion of this years ago. Can the president pardon himself? No. because you can't be the judge in your own case. Now, it's never been tested before, so we don't know. President Trump can avoid all of these debates, though, by simply resigning on January 19th for a day, allowing the Vice President Pence to be put into office, and then have Vice President Pence pardon him. And some people have speculated that that's what he's going to do. So the short answer, the short summary of a long answer is we don't know, but a textualist argument, a philosophical argument, strongly suggests the president cannot pardon himself.
Until recently, I'd never heard the term preemptive pardon.
Well, that's what Ford did. When Ford pardoned Nixon, Nixon had not been indicted at the time he resigned. He was under no criminal indictment. Matter of fact, I had lunch with one of the lawyers, that was on prosecuting the Watergate. And this lawyer, we were out for lunch, and says, yeah, I got to tell you, Devin, we had the indictment ready to go. We were waiting for him to resign or get impeached because there's a fair amount of non-binding precedent that you can't prosecute a sitting president. We were ready to go. And then we got word from on high, don't do it. Because President Ford was deciding whether to give a preemptive pardon. Even though you haven't been prosecuted yet, I'm going to pardon you for all crimes you committed in the past, so nobody can prosecute you in the future. Another historical tidbit, a local law firm wrote the memo for President Ford on that exact issue. President Ford didn't want a Washington, D.C. law firm because it'd leak. So he came back to Grand Rapids and asked a Grand Rapids law firm the question of whether he could give a preemptive pardon.
A number of years ago, we had Stephen Ford speak at the Presidential Library, and if my memory serves me correctly, he talked about once his father knew once that he pardoned Nixon that he would not be reelected, and he took that risk.
And the great thing about that is Ted Kennedy just assailed President Ford at that point, and then 15, 20 years later, the Kennedy Foundation gave him a Profile in Courage Award, and Ted Kennedy said, I got it wrong. You got it right.
Yeah. So just one more on the pardon topic. Would a pardon have, what effect would a pardon have on an ongoing investigation? So if we saw a pardon occur with President Trump, what does that mean for our future?
Dead stop on the president because he's been pardoned. And based on the Ford pardon, any crime he committed, if there were such crimes, that would be investigated before the pardon on the federal level. It doesn't give the president immunity on the state level. We are a dual sovereign. We have the state sovereign, which is a separate government. My next door neighbor, separate sovereign, and the federal sovereign. Constitution only lets the president pardon people from the federal system. And we know that on the state system, the state attorney general in New York has all kinds of interesting investigations going on. Pardon would not affect those investigations. Civil, criminal, who knows, but it only provides partial protection. And in fact, there's some reasons why you may not want a pardon, because under a case called Verdict from 1902, you accept a pardon, you are admitting guilt. President Ford carried around to the day he died a little card with the verdict quote in. So when people said, well, you let Nixon off the hook. No, I didn't. He essentially pled guilty. But you plead guilty in the Fed, that doesn't look good if you're getting prosecuted in the state, and you lose potentially Fifth Amendment protections. So pardon's not all it's cracked up to be, is my point.
I fibbed a little because there are more questions coming in about the preemptive pardon on the first children, Trump's kids, friends. Can the government get creative? And Corey's asking, can the government get creative in charges, or is it better to leave it to the states?
Well, the thing about the pardon is it's one of the few unchecked powers. Everything else the president does is pretty well checked. Commander in chief, well, but the Congress has to pay for it. Congress gets to regulate the Army, Navy, and the militia. Appointment power, checked, because the Senate has to approve his appointments. The pardon power is really the president's only unchecked power. He can do just about anything he wants. And so as Ford did, he has the authority to give very broad pardons for past crimes. What he can't do is give a pardon for a future crime. So he gives the pardon, take a snapshot in time. Everything that occurred before that date is off the table at the federal level, but not the state level.
I want to go, is interesting comment here. Is Sylvia still here, or did she leave? She did leave. I don't see her on the, okay, Professor Randall is back. Professor Randall, you had a question way on, and I called on you, and you weren't here. Do you want to, I'm scrolling now. Do you want to go back and ask your question so that we can address that? I'm trying to find it again.
Sure. Sorry about that.
There you are. Hi.
Yeah, hi. I'm hosting office hours at the same time for my students.
Gotcha.
So my question, if it ever gets there, Devin or Professor Schindler, is to your point about the delegation of power by the Michigan legislature to the Attorney General's office to conduct the election process. Does that, assuming we ever get to the merits, does that take care of the argument under the Electoral Clause?
Yeah, Professor Randall, as you so often do, you've gone right to the meat of the matter. Just to be clear, I think the standing issues, the latches issues, the lack of any remedy, I think they don't even get there. But let's assume they get there. If we apply the federal rules, broad delegations of authority are allowed, where the Congress can set forth broad goals. Run this election in a fair, equitable manner. If there's a natural disaster, you have additional authority. Those kinds of delegations have been upheld consistently by the United States Supreme Court. So it really is a question of, was the power appropriately delegated? And I've read some of the statutes, and it would appear the Secretary of State has pretty broad authority. And so if they were to apply, it's called the intelligible principle doctrine for those of you who are keeping track at home of these geeky terms. If they follow the intelligible principle argument, I think the Secretary of State has a pretty strong argument that she is the law-making authority, which is the definition. She is the law-making authority in the state because the legislature has made her the law-making authority in our state. It's a tougher argument for Pennsylvania, frankly, where the court implemented these rules because they did not get delegated authority. They did it under their constitution. That's a tougher question, but I think Michigan has a pretty good argument that because of the delegation of authority, she is now the quote-unquote law-making authority in our state for elections.
And do you know, because that was the first thing that jumped out at me merit-wise when I saw these, other than the standing issue. Do you know if that's the case with other states that have been sued?
Yep. The different rules are getting attacked. In Pennsylvania, it was the Pennsylvania Supreme Court that said, you get 3 more days. You have to count ballots that are received after 3 days. That is nowhere in any legislation. They weren't delegated that authority. They just said our inherent authority as final arbiters of the Constitution. Their Constitution has a fair elections clause, and they said, well, fair elections means you need more time without specific legislative authority. But in Wisconsin, Georgia, et cetera, it's variation on the same theme. Look, the state houses are not going to write the rules, to the granular level. Yeah, if it's Tuesday at 2 o'clock, you can do this and this and this and this, and what they're going to do is write broad rules and let the secretaries of state fill in the blanks. And that's essentially what the Secretary of State did, is filled in the blanks.
Laura Kane has a question, a specific question that she's kindly asked to kind of get addressed. So Laura, go ahead and take it away. If you want to unmute yourself and turn your camera on if you're able, that would be great.
Hi, Professor Schindler. It's great to hear you again. My question was on prior restraint of speech that is verifiably false. Do you think that a narrowly tailored law that of prior restraint of false speech could ever get by the court?
Hello, Ms. Kane. Nice to see you. I suspect you're studying for the bar. The case is, okay, Schindler, here we go. Am I 60? I'm almost 60. Can I remember the name of the case? I am not remembering the name of the case. I'm sorry. There is a case having to do with a decision was The court determined that a series of books are pornographic and therefore unprotected speech. So this bookseller had 50 pornographic books in his back room. He wanted to sell them. He was enjoined. He said, prior restraint. Let me sell them and then prosecute me. Court said, you can enjoin unprotected speech. You are allowed, if the speech is unprotected, you are allowed to enjoin it. So there is a case directly on point here. Interestingly enough, in these election cases, there really haven't been much of any First Amendment claims made. There's not much of an argument for First Amendment claims here. Some argument that voting is a form of speech. I saw the argument made that because it's a form of speech, you are imposing burdens on my ability to speak. Those claims got absolutely no traction at all.
So we're coming up on the 6 o'clock hour here, and I think probably a good place to end the conversation today is a very, probably the fundamental question. With all the attacks on the election process, the electoral process, is this irretrievable? Is there damage that can't be undone?
The United States Constitution is a piece of paper. It depends on the goodwill of the people and the respect the people show the document and the court. Again, maybe I'm naive, but I am refreshed because I work with lots of young people who are idealistic, who believe in the document, and are going to law school in part to defend the document. So my worldview may be somewhat cloistered, but by golly, so long as schools like Cooley Law School exist and other law schools exist that continue to send out these very fine young people that are willing to defend this document, I think this polity can last 200 more years. But it's not just the responsibility of young lawyers. I'm delighted so many people showed up. You know who else I can rely upon? I can rely upon Kim O'Leary, Dee Boyd, Corey Volmering. I can rely on John Campbell, Graham Ward, Mabel Martin Scott. I'm just reading the names of them. I can rely on all of these people to, one, reach out to the other side and say, let us find common ground. Because you know what the one principle the founders believed in more than anything else, the one principle they would never move from, the principle of compromise. The Constitution is a great compromise. It's time for us to, again, find that core belief that we are all Americans rooted in this document and find that compromise. So again, am I naive? Maybe. I'll never get 20%, but that doesn't mean I can't get my neighbors 2 doors down and say, hey, we voted differently, but we're still Americans. Let's be friends. So it starts with all of us. I feel like Mike dropped Schindler out with that one.
Might as well. Professor Schindler, there are so many comments in the chat just applauding you and how much you've meant to them both in their education and what a great conversation we had today on a very timely and important topic, obviously. I'd like to personally and on behalf of the law school, thank you for doing this.
The honor and pleasure was all mine.
Thank you. Thank everybody who attended. We'll be back in January with our program, including Martin Luther King Jr. And hope you'll be able to join us then. Look out for some more information about that. Meantime, let's everybody stay healthy. Have a great holiday season, and we'll see you in January. Take care, everybody.